everyone, welcome back to the channel. My name is Varun Kaushal and I'm a legal intern at LEXIS and Company. Today I'm going to discuss about approach of Romeo and Juliet laws in India. The Madras High Court in the case of Sabari at Sabarinathan at Sabri Vasan versus the Inspector of Police and others said that consensual relationships between teenagers aged between 16 and 18 years who are infatuated or innocent should not come with the purview of the protection of children from sexual offences. POSCO Act 2012, which awards not less than 7 to 10 years of rigorous imprisonment for such acts. It further said that a child should be defined as someone below 16 years of age instead of the current 18. The court was dealing with a case involving a runaway couple. A POSCO case was lodged by a man who alleged that the accused had kidnapped and committed penetrative sexual assault upon his 17-year-old granddaughter. The accused in the case was the granddaughter's co-student who was above the age of 18 years. India is a signatory of to international conventions which prescribe that the age of children is 18. The Juvenile Justice Act, the POSCO Act, the National Commission for Protection of Child Rights, and other related acts all say that up to 18 years, a boy or girl is considered a child. One can vote, open a bank account, and own a property when he/she attains the age of 18. But POSCO has decreased the age of a child to 16. The relationship between a girl under 18 years of age and a teenage boy or little over the teenage years cannot be construed as alien or unnatural. The protectionary provisions intended to protect children from sexual predators and child sexual exploitation are increasingly being used to penalize consensual sexual relationships amongst adolescents or between an adolescent and an adult. Both the POSCO Act and the Indian Penal Code set the age of consent at 18 years and deem minors incapable of giving consent. Where two minors engage in a consensual sexual relationship, in a paradox, they stand both as victims and perpetrators vis-a-vis each other. Although ground level reality results in boys being overwhelmingly treated as perpetrators and girls as victims. Also, the punishment for having sex with a minor is minimum 10 years imprisonment under the POSCO Act, and the mandatory minimum sentences under the law provides absolutely no discretion to judges to consider mitigating factors and impose a lesser sentence. Pursuant to the Criminal Law Amendment Act of 2018, for having sexual intercourse with a child younger than 16 years, the punishment is a minimum of 20 years imprisonment, which may be extended to imprisonment for the remainder of the life of the offender. These laws enacted for the protection of children betray a paternalistic approach under complete ignorance of the increasing sexual exploration among adolescents, a trend that is both healthy and part of this the normal development of older children. Also, the Madras High Court in the case of Vijayalakshmi and ANR versus State stated that an adolescent boy and girl who are in the grips of their hormones and biological changes and whose decision-making ability is yet to fully develop should essentially receive the support and guidance of their parents and the society at large. These incidents should never be perceived from an adult's point of view, and such an understanding will in fact lead to lack of empathy. An adolescent boy who is sent to prison in a case of this nature will be persecuted throughout his life. Professor Ved Kumari, Dean of Delhi University's Law Faculty, stated that in consensual sex both are offenders or both are victims. It has been my long held position that either both need to be tried under the JJ Act or both should go to the CWC, that is Child Welfare Committee. Normally the boy is tried under JJ and the girl is sent to CWC. They are equal partners. How can the two be treated differently? In a study conducted by the Hindu on 600 cases of sexual assault in the state of Delhi in 2013 showed that amongst the cases fully tried, 40% dealt with consensual sex, typically involving elopement of young couples, and criminal complaints filed by the girls' parents who object to such a union. Also, the studies of the CCL-NL-SIU on the functioning of special courts under the POXO Act 2012 in 5 states offer interesting insights into the way sexual relationships involving minors and the concept of minors is treated by special courts. The studies define romantic cases as cases in which the victim admitted to being in a romantic relationship with the accused at any stage of the investigation or trial, or in which a romantic relationship was inferred by the judge based on the facts or evidence placed before her. The treaty body of the UNCRC, the Committee of the Rights of the Child, has also addressed the concerns relating to the statutory rape laws around the world and has categorically stated that states parties should take into account the need to balance protection and evolving capacities and define an acceptable minimum age when determining the legal age for sexual consent. States should avoid criminalizing adolescents of similar ages for factually consensual and non-exploitative sexual activity. In State versus Akhilesh Harichandra Mishra, the victim was 15 years old when she eloped and married the accused. They had a child before the trial was committed. The accused was acquitted because the informant stated that the couple was married and she had no grievances. The special court noted that the matter had been compromised. It rejected the PP's argument before about consent being irrelevant under the POCSO Act. Sexual intercourse with a person below its age is considered statutory rape. To address the increasing number of adolescents and young persons being punished for consensual sex, states additionally enacted laws termed as Romeo and Juliet laws, which provide for a defense in such cases. Romeo and Juliet laws provide some degree of protection to offenders of statutory rape laws where the minor has consented to the sexual intercourse and where the age difference between the minor and the alleged offender is less. An age gap provision under which consensual sex with a person just a little older is prevalent in many jurisdictions. That prevents a much older person from exploiting the minor because crushes are also normal at this age. Justice V. Parthiban ruled the definition of child under Section 2D of the POCSO Act can be redefined as 16 instead of 18. Any consensual sex after the age of 16 or bodily contact or allied acts can be excluded from the rigorous provisions of the POCSO Act, and such sexual assault, if it is so defined, can be tried under moral liberal provision, which can be introduced in the Act itself, and in order to distinguish in the cases of teenage relationship after 16 years from the cases of sexual assault on children below 16 years. The Act can be amended to the effect that the age of the offender ought not to be more than 5 years or so that the consensual victim girl of 16 years or more, so that the impressionable age of the victim girl cannot be taken advantage of by a person who is much older and crossed the age of presumable infatuation or innocence. Justice V. Parthiban observed, directing the government authorities to place the decision before the competent authority and initiate appropriate steps to explore whether the suggestions made by this court are acceptable to all stakeholders. While legal experts and child rights activists welcome the redefinition of child, some of them call for further discussions on the suggestion for an amendment that would factor in the age difference. That's it for today's video. Thank you for watching. If you guys have any questions regarding the video, please do ask in the comment section, and don't forget to like, share and subscribe the channel LEXCLIQ.